Today we're with John Kelly. John Kelly is a personal injury attorney in Phoenix, Arizona. He's agreed to answer some of the questions that were posted online, and for those of you who have posted those questions, you're going to get your answers right now. If alternatively, if you're looking for a personal injury attorney, you can feel free to give him a call. Also, John has agreed to answer any of the questions you have directly by just simply posting them on the bottom of this YouTube video. So with that said, John, let me go ahead and start off with some of the questions here. The first question we had. The person asks, I have a work-related lawsuit, and I believe it's a fairly strong case. I would not like my employer to know what I'm considering while pursuing the case. If the case doesn't work out, just in case the case doesn't work out, is this something possible, basically to hide it from your employer?
Okay, there is a certain amount of the case that you could hide. The initial stages of investigation is something that you can consult with an attorney. That attorney can talk to you about what the likelihood of your case being successful is, whether there's some things that the attorney can do to get an investigator working on it, or experts evaluating you for your injury to determine if that's a pursuable case. At some point, it's not going to be a secret, and you can't keep that secret when you want to actually pursue the case in the legal system in that sense. So if you want to actually get a settlement out of the case, or win with a lawsuit further down, that's going to be something that's going to take notification to your employer. Another issue with this is sometimes there's general rules with how soon a person has to notify their employer of an injury that had happened at work. So if we're talking about an injury at work, it's a good idea to notify your employer at least that you had that injury and that you're getting treatment for that. And then I would recommend talking to an attorney right away about at least exploring your possibilities of what kind of case you might have, not necessarily needing to inform your employer right away that you're pursuing a lawsuit.
Okay, all right, well, no, that makes total sense. Next question we have is, and I'm sure you get this one all the time, if I win my case, how long will it take to collect my money?
Okay, so there's two ways to win your case in a personal injury case, and I'm assuming one of those ways that people feel like they've won is if they settle out of court. The other way is to actually go to trial and have a jury verdict and have a verdict from the jury, and so those can kind of make the answer to it a little bit different, but generally it should happen within 30 days that you could get your money, and that's there's a lot of other factors. There's attorneys involved on the other side that may need to get you some documentation, a release form. Insurance companies, when we settle, they often have to write a check, and some of these insurance companies are very big, so they have a lot of files that they're dealing with and a lot of checks that they're writing. The other issue is that your attorney will need to put the funds, once they receive those, into a client trust account, and in Arizona the requirement is that they put that check in an IOLTA account for 10 days at least to make sure that the check clears. So there are some things that prevent you from getting the money immediately, but it generally is around 30 days. It can be longer though.
Okay, all right, and another question. This is probably an extension of that. Well, here's the other one. Will I be able to testify in court? Will I be required to testify in court like in a criminal case, in a personal injury type of case?
Not always, and most of the time you would not need to testify in court. I had talked about earlier about cases settling outside of trial, and there's a good majority of the cases that actually do settle without ever going before a judge. And in this instance, it's likely that you would not have to provide any testimony. Now, that is a separate issue from whether you provide statements to the adverse insurance company or your own insurance company, and those aren't usually settings where you would have to be in front of a judge testifying like people think about as a court setting. But you may have to provide statements. Now, if you go to trial, then you would need to provide your own testimony in most cases, and you would be in front of a judge and a jury, and you would provide your testimony like you see on TV with criminal cases. So it's very unlikely in the typical case. I wouldn't say it's very unlikely, but it's unlikely in the typical case, but it does happen.
Okay. Well, those were the questions that were posted online. We have some other questions that will be asked later on. If you're watching this, and like I said, if you have any questions for John, John's agreed to answer the questions online, so just post them to the comment section, or obviously you can just give John a call. So, John, I want to thank you for your time.
Thank you, Ryan.